You married an American citizen. You thought your green card was guaranteed. But right now, thousands of spouses are being denied, detained, and separated from their families because they believed the same thing. I'm about to expose what USCIS doesn't want you to know. If you or someone you love is married to a U.S. citizen and waiting for that green card, the next 3 minutes could save your American dream. Don't skip this. The immigration attorney's warning came like a thunderclap through the community, and within hours, panic spread across immigrant families from California to New York. Marriage to a U.S. citizen, the golden ticket that millions have believed would automatically secure their future in America, is no longer the safety net it once was. The message was clear, direct, and terrifying. Marriage alone will not get you a green card anymore. Let me tell you about Maria. She met her husband David at a coffee shop in Austin, Texas. They fell in love, got married in a beautiful ceremony surrounded by both families, and filed for her green card adjustment of status. Maria thought she had done everything right. She had her marriage certificate, joint bank accounts, photographs spanning 2 years, and even a lease with both their names on it. But when she walked into her USCIS interview 8 months later, the officer looked at her documents, asked a series of increasingly hostile questions, and then said the words that shattered her world. "I'm not convinced this marriage is bona fide. Your application is denied." Maria was placed in removal proceedings 3 weeks later. Her husband sat in the courtroom, helpless, watching his wife fight deportation despite their genuine, loving marriage. This is not an isolated case. This is the new reality of marriage-based immigration in America. And if you don't understand what's happening right now inside USCIS field offices and immigration courts across the country, you could be next. For decades, marriage to a U.S. citizen has been considered the strongest pathway to lawful permanent residence. The law is clear. Immediate relatives of U.S. citizens, including spouses, are not subject to numerical caps or long waiting periods like other family-based categories. On paper, the process seems straightforward. You marry a citizen, file Form I-130 and Form I-485 if you're already in the United States, attend an interview, and receive your green card. Millions of families have successfully navigated this journey. But what worked 5 years ago, or even 2 years ago, is colliding with a dramatically different enforcement landscape today. The shift began quietly. USCIS officers started receiving updated training protocols emphasizing fraud detection. The agency hired more fraud detection specialists. Interview techniques became more aggressive. The burden of proof, while technically unchanged in the regulations, expanded enormously in practice. Officers were given more discretion to deny cases based on subjective assessments of credibility. The definition of what constitutes sufficient evidence of a genuine marriage kept growing more demanding. And perhaps most dangerously, the consequences of any inconsistency, any missing document, any perceived red flag became exponentially more severe. Immigration attorneys across the country started seeing patterns that sent chills down their spines. Cases that would have been approved with a simple request for additional evidence 5 years ago were now being denied outright. Couples who had been married for years, who had children together, who had built entire lives together, were being accused of marriage fraud based on the smallest discrepancies. An officer might decide that a couple didn't know enough details about each other's daily routines, or that their wedding seemed too small or too large, or that they didn't have enough photographs from a specific time period, or that their body language during the interview suggested discomfort. These subjective judgments, once rare exceptions, have become routine bases for denial. But here's what makes this situation so much more dangerous than previous enforcement waves. It's not just about fraud cases anymore. Genuine couples, people who are truly in love and building authentic lives together, are getting caught in a widening net of suspicion. The presumption of innocence that once existed in marriage-based cases has been replaced by a presumption of fraud. You are no longer assumed to be legitimate until proven otherwise. You are now assumed to be committing fraud until you can prove beyond any doubt that your marriage is real. Understanding why this is happening requires looking at the intersection of politics, resources, and enforcement priorities. Immigration has become the most politically charged issue in America. Every administration, regardless of party, faces enormous pressure to demonstrate they are tough on illegal immigration and fraud. Marriage fraud has been highlighted in countless news stories, congressional hearings, and policy debates. While actual marriage fraud represents a small percentage of total marriage-based applications, the political optics demand visible enforcement action. USCIS officers are responding to this pressure by increasing scrutiny across the board. And unfortunately, that means genuine couples are being treated like potential criminals. The consequences of a marriage-based green card denial have also become dramatically more severe. In the past, if your application was denied, you might have the opportunity to reapply or appeal the decision while remaining in the United States, especially if you had maintained lawful status. Today, a denial frequently triggers immediate removal proceedings. Immigration and Customs Enforcement, ICE, receives automated notifications of certain denials. Individuals who are denied may receive a notice to appear in immigration court within weeks or even days. Once you're in removal proceedings, everything changes. You're now defending against deportation. Your case moves from the civil administrative system of USCIS into the adversarial environment of immigration court. The government has an attorney whose job is to remove you from the country. The burden of proof shifts. The costs skyrocket. The stress becomes unbearable. And your U.S. citizen spouse, who thought their marriage would protect you, discovers they have far less power than they believed. There are also hidden traps that catch people completely off guard. Consider the issue of prior immigration violations. Maybe you entered the United States without inspection years ago. Maybe you overstayed a previous visa. Maybe you worked without authorization before you got married. You thought that marrying a U.S. citizen would forgive these violations. And technically, in many cases, immediate relatives of U.S. citizens can apply for waivers of certain grounds of inadmissibility. But here's the trap. When you apply for adjustment of status based on marriage, you are putting yourself under intense scrutiny. USCIS will examine your entire immigration history. If they find violations, they may deny your adjustment and place you in removal proceedings. The very act of applying for the green card can expose you to deportation, even if you've been living peacefully in the United States for years. Then there's the 3-year and 10-year bars. If you accrued unlawful presence in the United States for more than 180 days but less than 1 year, and then you leave the country, you trigger a 3-year bar to re-entry. If you accrued more than 1 year of unlawful presence and leave, you trigger a 10-year bar. Many people don't understand that simply applying for a green card based on marriage doesn't erase unlawful presence. If you're required to leave the United States for consular processing of your immigrant visa, you could trigger these bars and find yourself trapped outside the country, separated from your spouse and children for years. The interview process itself has become a minefield. Officers are trained in interrogation techniques designed to catch inconsistencies. They may separate spouses and ask identical questions to see if answers match perfectly. They may ask deeply personal questions about intimate aspects of your relationship. They may challenge you on minor details about your home, your daily schedule, your spouse's family members. One couple was denied because the husband couldn't remember the exact date his wife started her current job. Another couple was denied because they had different recollections of what they ate for dinner on a specific date months earlier. These are the kinds of details that even genuine couples might not remember perfectly, but in the high-stress environment of a USCIS interview, any inconsistency becomes evidence of fraud. The evidence requirements have also expanded dramatically. It's no longer enough to show you're married. You must prove you have a real, ongoing, shared life. That means joint financial accounts, but also evidence of joint transactions. It means a shared residence, but also evidence that you both actually live there, with mail addressed to both of you, utility bills in both names, and statements from landlords or neighbors. It means photographs together, But not just wedding photos. Officers want to see pictures spanning the entire relationship at different locations with different people, showing genuine affection and intimacy. It means affidavits from friends and family, but those affidavits must be detailed and specific, not generic statements of support. It means evidence of shared responsibility, like insurance policies, wills, power of attorney documents. The list keeps growing, and what was considered comprehensive documentation 3 years ago may be deemed insufficient today. Cultural differences can also trigger red flags that lead to denials. If you come from a culture where arranged marriages are common, officers may be skeptical of your relationship even though arranged marriages can be completely legitimate. If you and your spouse have a significant age difference, expect extra scrutiny. If you married quickly after meeting, officers will question whether you had time to develop a genuine relationship. If you married shortly after a previous relationship ended, you may be suspected of a rebound marriage of convenience. If you come from a country with high rates of immigration fraud, you'll face additional suspicion regardless of your individual circumstances. Language barriers create another layer of danger. If you and your spouse don't speak the same language fluently, officers may question how you communicate and whether you truly understand each other. If you need an interpreter for your interview, every word will be scrutinized. Misunderstandings caused by translation issues can be interpreted as lies or inconsistencies. And if your spouse speaks your native language, but you're using an interpreter at the interview, officers may wonder why your spouse isn't interpreting for you, which can create suspicion about the authenticity of your relationship. Then there are the cases where marriage genuinely isn't enough because of legal bars that cannot be waived. If you entered the United States with a K-1 fiancé visa but then married someone other than your petitioner, you generally cannot adjust status in the United States and must leave the country for consular processing, which may trigger bars to re-entry. If you've been involved in certain criminal activity, even minor offenses, you may be inadmissible. If you've made misrepresentations to immigration officials in the past, you could face permanent bars. If you've been previously removed or deported, you may need special permission to even apply for a green card. Marriage to a U.S. citizen doesn't automatically overcome these obstacles. There's also the conditional green card trap that many people don't fully understand. When you receive a green card based on a marriage that is less than 2 years old at the time of approval, you receive a conditional green card that's valid for only 2 years. Before that 2-year period expires, you and your spouse must jointly file Form I-751 to remove the conditions and obtain a permanent green card. This requires proving all over again that your marriage was entered into in good faith and is still valid. If your marriage ends in divorce during those 2 years, removing conditions becomes exponentially more difficult. You may need to prove that you entered the marriage in good faith, even though it didn't work out, or that you would face extreme hardship if forced to leave the United States, or that you were the victim of abuse. Thousands of people receive conditional green cards every year without fully understanding that they're not actually permanent residents yet, and that the conditions removal process can be just as difficult as the initial application. What makes all of this even more heartbreaking is that many people learn about these complications only after it's too late to fix them. They didn't consult with an immigration attorney before getting married. They didn't understand the importance of documenting their relationship from the beginning. They filed their applications themselves, using forms they downloaded online, and made critical mistakes that now can't be undone. They went to their interview unprepared, answered questions without understanding the implications, and said things that hurt their case without realizing it. And now they're facing denial, removal proceedings, and the possibility of losing everything they've built in America. The attorney's warning is not meant to discourage genuine couples from pursuing marriage-based green cards. It's meant to wake people up to the reality that marriage alone is not a guarantee. It's meant to emphasize that the process requires careful preparation, extensive documentation, legal knowledge, and strategic thinking. It's meant to highlight that what you don't know can destroy your case, regardless of how genuine your marriage is. Right now, there are people reading this who are in Maria's exact situation. You're married to a U.S. citizen. You thought you were safe. You haven't started gathering evidence because you assumed your marriage certificate would be enough. You haven't consulted an attorney because you thought the process was simple. You haven't been keeping detailed records of your relationship because you didn't know they mattered. And you're heading toward an interview or a filing deadline completely unprepared for the level of scrutiny you're about to face. The time to act is not after you receive a denial. The time to act is right now, before you file, or immediately if you've already filed. You need to understand what USCIS is looking for. You need to gather comprehensive evidence that tells the complete story of your relationship. You need to prepare for interview questions that will feel invasive and uncomfortable. You need to review your entire immigration history for potential red flags. You need to understand the legal requirements and potential obstacles specific to your situation. And in most cases, you need professional legal guidance from an immigration attorney who handles marriage-based cases regularly and understands the current enforcement environment. The stakes could not be higher. This is not just about a green card. This is about your ability to stay in the country you call home. This is about not being separated from your spouse and children. This is about your career, your education, your community, your entire life. One denied application can trigger consequences that follow you for decades. One mistake in an interview can result in deportation. One missing piece of evidence can be the difference between approval and removal proceedings. The American dream that brought you here, the love that led you to marry a U.S. citizen, the hope you have for your future, all of it depends on understanding that marriage is just the beginning of the journey, not the end. The law creates a pathway for spouses of U.S. citizens to obtain green cards, but that pathway is filled with obstacles, requirements, and scrutiny that can trap the unprepared. Immigration officers are trained to find fraud, and in that environment, every genuine couple must prove they are the exception. This is your moment to take control of your case. This is your opportunity to learn what you need to know, gather what you need to have, and prepare the way you need to prepare. The next person who walks into a USCIS interview unprepared and gets denied could be you, or it could be someone you love. The next person who gets placed in removal proceedings after believing their marriage would protect them could be your family member, your friend, your coworker. But it doesn't have to be you if you act now. If this information opened your eyes to something you didn't know, if it made you realize you need to take action, if it gave you insight that could protect your future, then help me reach more people who need this warning. Subscribe to this channel right now for daily updates on U.S. immigration, because what you don't know is what will hurt you, and I'm here every single day breaking down the policies, the processes, the changes, and the strategies that can save your American dream. Hit that like button so more immigrants find this video before they make mistakes they can't fix. Share this with anyone you know who is married to a U.S. citizen or planning to apply for a marriage-based green card. Drop a comment below telling me your situation, your concerns, your questions, because this community is here to support each other and I read every single comment. Turn on notifications so you never miss an update that could change everything for you. Your story doesn't have to end in denial. Your marriage can lead to that green card. Your family can stay together. But only if you understand what you're really facing and prepare accordingly. The truth is hard to hear, but the truth is also what sets you free. Stay informed, stay prepared, and stay fighting for your future in America.